Gardner. And next up, we have Paul Rothermel with Privacy and Consumer Considerations. Paul specializes in privacy, cybersecurity, and healthcare compliance. Paul is senior attorney at Gardner Law, where he advises medical device and pharmaceutical companies on HIPAA, GDPR, and CCPA. Paul focuses on interpreting and applying privacy and security and cybersecurity laws, regulations, and standards to help his clients navigate evolving regulatory challenges, as well as general healthcare compliance matters. Thanks for being here this morning, Paul.
Thank you. Hi, good morning, everyone. I'm happy you can join us and talk about AI. It's an exciting topic. A lot is happening. And of course, if you're at all familiar with privacy, it's a busy area as well. And so privacy and AI definitely overlap in some really significant ways. And we'll see that through some of the slides I'll share and conversation topics. So we'll start here with some, and we'll focus on the US. There's obviously a lot of AI and privacy developments worldwide that we could talk about. We'll focus on the US today, but we do have to at least reference at some points what is happening and how that's impacting the US elsewhere. We'll focus on what are the privacy rules and laws in the US doing about AI and how has the US started to regulate AI from a consumer perspective. So we'll get that kind of look at things here. We'll end with a few examples of enforcement, and they typically we're seeing enforcement more from the federal government around AI. As Mark mentioned, the FTC has been active in that area, so we'll talk briefly about that as well. So let's go ahead and dive in. So what is happening in the U.S. right now is primarily direct regulation of AI is coming from the state level. So we're seeing the federal government. There's some activity at the executive order that the executive orders we're seeing coming from the previous administration trying to set some general safeguards and so forth um, that the federal government needs to align with around AI, and then some rolling back of that and kind of loosening of those rules in the current administration. Beyond that, though, we're not seeing heavy momentum at the federal level to regulate or restrict or kind of put up rules of the road generally for AI in the private sector. What we are seeing, though, are certain states are starting to jump in and try to regulate certain aspects of AI. So we're seeing things like the Utah AI Policy Act. California has a similar rule, and these are focused on what's called generative AI. And I believe Mark mentioned that in his presentation that generative AI is this AI that you typically would use like ChatGPT or um, Google Gemini, these different tools that you kind of prompt and work with and kind of develop, generate results and outputs. So there's rules that are starting to develop around those, and we've even had two laws pass so far, and more to come on that. And then uniquely right now, Colorado has already started regulating AI more broadly. So if you are following along with that set of rules, it does echo some of the things we're seeing in Europe. So Europe has passed an AI Act as of some time ago now, actually, and gradually that is implementing and becoming effective. But the idea there is that AI as a whole, these kind of AI systems as they're defined, need some regulation, some curbing, some control to protect individuals from the potential risks, whether that's some privacy concerns, but more main concerns are around discrimination or misuse of AI to make decisions where the individual might not have an opportunity to appeal that decision or have some input or things along those lines. HIPAA, of course, the Health Insurance Portability and Accountability Act, and all of the amendments of that through high tech and so forth, and the regulations that are implemented around that also have a lot to say about patient privacy and how information is used, and that impacts AI as well. And then, of course, the Federal Trade Commission Act doesn't directly regulate AI in any way, but a lot of activity around AI involves consumers and it impacts consumers. So we're seeing an interest from the Federal Trade Commission in how do we protect consumers from misuse of AI or potentially, deceptive activity with AI or other consumer protection concerns. So we'll talk some about that as well. On top of this, there are many, many, many state privacy laws that have passed just in the past 5, 6 years now. California kind of led the way with the California Consumer Privacy Act, but then many, many other states fell in line and found their own versions of privacy laws of varying levels, and all of them have a slightly different take on things. So we're seeing a lot of patchwork, sort of a patchwork, as we might hear it called, of privacy law developing. What's interesting about this and how it relates to AI, and we'll talk about a couple of examples coming here. There's an element of these privacy laws in many cases that regulates artificial intelligence use or AI use through this idea of automated decision-making tools. And so there's some regulation that overlaps between privacy regulation at the state level and these kind of AI protections that we're talking about today. And I also noted here there's a few states that are focused on consumer health data. So there, Washington is a great example of this, but New York just passed a bill similar to this. And also in Connecticut, we saw an amendment to their privacy law a couple of years ago. And then Nevada that have these consumer health data laws that are really specifically focused at health information that falls outside of HIPAA's protections. And, if you're familiar with HIPAA, it has a very specific sectoral bent towards interaction with insurance and how is insurance billed. So providers that interact with insurance are regulated by HIPAA, but there's a broad swath of organizations and companies and entities that handle health information frequently or regularly. And you might think of like those health and wellness apps that you use on your phone, other things along those lines. Those would be regulated generally by these consumer health data laws. And that fills this gap between HIPAA and these kind of these rules that don't, or these apps and uses that don't actually fall under the HIPAA rules. So what does HIPAA have to do with AI? And that I think this is an interesting starting point because HIPAA is not generally thought of as a AI regulation, and it really is not, but it has an impact, a significant impact on the health industry. Um, Most often in the medical device space and the pharmaceutical space where I kind of live is there's a lot of clinical trial and other kind of data collection activity that pulls data in and de-identifies it for use to develop a product or to further demonstrate the efficacy of products to the FDA, as Nate was talking about earlier. So there's ways to collect PHI, protected health information, and use it in AI functions, whether that's using it to feed a model or even on the kind of healthcare provider side, you can use AI to benefit patients through these clinical decision-making tools or even other kinds of more direct uses. But there needs to be, anytime you use patient information under HIPAA, there needs to be a basis for that. There's a series of permitted uses and disclosures that HIPAA allows. And some of those include things like use for healthcare operations or treatment, uses for payment, these various permitted uses or disclosures of PHI. But if there isn't one identified and you can't align the use of that data with one of these exceptions, well, then you have a restriction and you have to consider, do we need to get patient authorization? Does the patient have to consent to this use of data? Or can we de-identify data in a way that we're no longer subject to HIPAA? So we have these federal regulations that limit use of PHI, and that impacts AI directly as we're trying to determine what are the appropriate uses of patient information. Um, Federal Trade Commission, also at the federal level, well, we haven't really seen direct regulation in the sense that the FTC is not rulemaking, they're not writing regulations around artificial intelligence or privacy. We did see in the last administration, at least, significant activity around especially the use of data to create models that without, for example, adequate consent. So we saw some activity like enforcement against big tech or in some cases smaller tech, but really focused on how is data being collected? Is it properly used? Is there an adequate opt-in? And we'll talk about a couple of examples at the end of the presentation here of that kind of enforcement activity. But even just this week, the current administration has expressed a little bit of maybe a shift. We're still going to wait and see exactly what that looks like. but there's a concern of over-regulating AI or kind of limiting the ability to innovate. So there is a concern on that front that we're seeing expressed, and some of the prior guidance that the FTC has issued has been rolled back a little bit and sort of adjusted. So we're going to see probably a different emphasis, although the chair has also expressed to focus on consumer protection still, and AI is obviously a significant potential threat to consumers if used improperly. So there will be some correction, but probably some of the same kinds of activity going forward. Now, at the state level, we're seeing again not a lot of activity in terms of direct regulation, but it's developing. Colorado already has its own AI Act, kind of leading the way, regulating AI broadly. So it defines an AI system here to mean any machine-based system that for any explicit or implicit objective infers from the inputs the system receives how to generate outputs, including content, decisions, predictions, or recommendations that can influence physical or virtual environments. Now that's a lot of words and it means something, right? And it sounds like a pretty broad definition if you kind of just read it. And it is, it's a very broad definition. So the idea is it takes in all sorts of potential and it's an attempt, I think, to be forward looking and think about what might AI look like, a year, 5 years, 10 years from now. So it's broadly defined. And the attempt is to try to cover potential uses of AI or similar kinds of systems in the future that don't necessarily fit a more narrow definition at this point. And then there's this concept of high risk AI systems that's baked into this law that focuses more of the regulatory burden on those kinds of systems. So we'll talk a little bit more about that. So a high risk artificial intelligence system means any AI system that when deployed makes or is a substantial factor in making, quote, a consequential decision. So a consequential decision is a big emphasis point in the Colorado AI Act. And I will note one of the interesting things with this law is it was passed, it's on the books. However, there's some concern right now, the governor of Colorado, and there's been a task force assigned to look at this law and evaluate it and think about how do we improve this law? Because there's shortly after it was passed, there was a lot of discussion from industry and from lawmakers. How do we actually interpret some of these requirements? They're very broad and in some ways vague at points, like this phrase consequential decision. So there's been an ongoing discussion, and there was a report released in February from the Colorado this task force assigned to look at the law, criticizing and raising some issues that could be addressed through amendment. So we're probably going to see that happen before much more, enforcement or the Attorney General issues regulations. We'll probably see some amendment or at least some discussion of some amendments before that happens. But part of the requirements under this law are that developers, so those who create or develop a high-risk AI system, they have to provide those who actually use the system, the deployer. So let's say you are a tech company providing some sort of clinical decision support or something to a healthcare provider, to a hospital. You would need to, as part of sharing that or providing that system to the hospital, various kind of transparency statements about how would this potentially be used, potential harmful or inappropriate uses of the software or the AI system. Um, how did you train it to some degree? So there's some very kind of, I won't go through the whole list here, and there's more, but some of these are examples of information that would have to be shared by the developer of that system with the deployer. So just something else to note, there's a few exemptions, and I think I just repeated the high-risk AI system definition, but below that, there's this exemption. So some of the exemptions that we would look at, certain types of data use for HIPAA-regulated entities. Um, for example, if it's a non-high risk healthcare recommendation, it's hard to, again, know exactly what that means, but there are intended to be some exemptions for covered entities like a hospital or a healthcare provider that uses AI in certain contexts. Um, Also, certain technologies that are approved and certified or cleared by, for example, the FDA or other federal agencies, if those standards are substantially equivalent, whatever that means, but we again have some exemption. So those kinds of things are hopefully going to be clarified further when we see if we see any amendment to the law. But I do want to point out there are some exemptions available, particularly in the healthcare front. In California, we have the generative AI law that I mentioned earlier. And this defines artificial intelligence fairly similarly. You see that same idea of a machine-based system, um, has explicit or implicit objectives, infers from input it receives to generate outputs that influence, again, this phrase of physical or virtual environments. And then it defines generative AI in a more specific way. And these generative AI rules are largely focused on how do we protect consumers and ensure that privacy or not privacy, but consumers are protected from potential misuses, or at least there's transparency around what is this AI designed to do? How does it function? What kinds of data were used to train that device? And on the privacy front in California as well, so the CCPA and other state laws, but we'll focus on the CCPA here. There's also this concept in the privacy rules, as I noted right early on in the presentation, that these these privacy rules also regulate AI in sort of a interesting way where we have data inputs. So obviously use of data is regulated. So what kind of data is used to train models is relevant. Is it personal information? Should you have consent, or are there other bases, de-identification, for example, to use that data? But also on the other end, um, many of these rules address the use of what's called automated decision-making technology. And that is particularly focused on things like profiling. So using broad sets of data about an individual to draw and infer conclusions about them. So you might have, you know, 99 data points and you're missing one data point. Well, using a machine learning process, you might infer that 100th data point about an individual and profile them in a way. And when what the rules are most concerned about is when that profiling leads to a decision. So you might have a healthcare decision, or insurance eligibility decision, various other kinds of activities that companies might use, creditworthiness, et cetera. And those elements of data are not only collected, but then assumed based on a machine learning type of activity. So California and many other states have addressed automated decision making through their privacy rules. So as I noted on the previous page, the Attorney General, and I think I just glossed over this, but the Attorney General in California is authorized to make rules, and particularly around automated decision-making technology. So we do have a proposed regulation that's in draft already covering this, and it notes, we noted in the Colorado discussion that there is vagueness around this idea of a significant decision. Well, in California, they've started defining that in their draft regulations, just to give us an idea of what that means. For purposes of this article, significant decision means a decision using information that, there's some exceptions, that results in access to, provision, or denial of, and I'll just highlight here, insurance, healthcare services, or essential goods and services, and medicine is captured in parentheses there. So these are some examples of what California is thinking about in its draft regulations, including in a significant decision, as far as what makes an AI system that's regulated by this privacy law. And with that, of course, comes various rights. So if there is an automated decision making technology that's used to make a significant decision, that typically means that individual consumers have opt-out rights unless there are certain other criteria met. For example, you would have to allow a human reviewer, an appealable decision made by a human reviewer, in some cases to avoid having opt-out apply, et cetera. So there's ways that California is thinking about consumer protection in this front. So I'll kind of speed through this part, but again, consent may be appropriate to use personal data to do these kind of algorithmic training activities. You can see that in many, many privacy laws around the country and the state level. So I'll just kind of highlight here a recap of this. So use of personal data to train AI, significant, a very significant part of privacy and its impact on AI. Potentially, you could have a breach, and I'll mention this just at a high level, but if you use an AI system and your organization um, puts information into, say, a generative AI tool, there's always a risk there that that data that's shared with that third party is misused, is there could be a breach. You might be inadvertently sharing it across borders through, um, this is most relevant, for example, let's say you're in Florida and you're dealing with a rule that restricts non-continental US use of this data. There's some of those kinds of rules that are becoming more common. Um, or if you're in Europe and sharing across the Atlantic into the US, those kinds of data sharing activities can be on their own violative of privacy laws or even result in data breaches, et cetera. So there's always that concern when it comes to AI use, especially by companies or entities that handle personal information and patient information. We mentioned the automated decision making and how that can, in a way, be a privacy violation. For example, profiling, that inference of data about an individual, or making significant decisions about individuals using those tools. And then, of course, if you are in an enterprise, that's using AI, if you kind of go out and individually use an AI system, and plug in data, et cetera, you typically don't have protections. That data usually then is owned by that organization that provides the tool. So if you go and use ChatGPT on the internet on your own, um, putting personal information or other things into that AI that belongs to the company or to those individuals could be a privacy violation. So we always look to have our clients use enterprise agreements with those AI tools and ensure that privacy protections are incorporated, IP protections, and so on. So those are all considerations when using AI as a part of your work. So I'll just close with a few examples and some case guidance that we're seeing. California, typically does have a strong interest in AI and kind of these emerging technologies, and is in some ways leading the way on regulation of privacy and AI and other related activities. So there was a recent legal advisory that the Attorney General released that's really focused on AI and how it's used in the healthcare sector. And it's not making new law, it's simply pointing to various existing laws and highlighting some of the concerns that the Attorney General is identifying and concerned about, and highlighting them for industry. Some of the considerations from this that I'll point out, there's more there, and I encourage you to look at that if you're curious about this topic. There's a lot of kind of legal theory that's discussed. But some considerations to highlight, the AG was concerned about transparency, so patients knowing when and how their information is used to train AI, and how providers might use AI when making decisions about the patient. Concern about accuracy. So there's a very common use case of AI right now to draft patient notes. So you might even have devices that listen to your visit at the doctor or clinic, where you're automatically getting transcriptions of those visits, and even sometimes that data is automatically entered into records. So accuracy in that, and how is that disclosed to patients is a concern. Medical practice, just ensuring that healthcare provider decision making is still maintained by the healthcare provider, so that AI doesn't take the place of healthcare decision making. As Mark mentioned early on in this program, prohibitions on discrimination, so concern about individuals being disproportionately impacted by algorithmic decisions or activities there. And then this idea of informed consent, I think, is very interesting. So using informed consent principles that we typically see on the medical provider side um, in the context of AI use. So if there's an AI tool that's being used to support treatment, what about informed consent? And is that being sought from the patient? And then I'll just mention briefly, although I think we're getting close to time here, just a couple of examples from the FTC. Um, there hasn't been a significant amount of enforcement on AI to date. There's been some. One of the emphases from the FTC, though, over the past few years, and even going back a decade or more, is privacy and cybersecurity enforcement from the Federal Trade Commission, and that's extended a little bit into AI, although the focus there has been more on kind of deceptive marketing of tools that use AI. But where it has impacted AI is this idea of data use. Um, is health data or other sensitive or even children's data used to train AI? And if so, is that data, properly collected or shared or sold, depending on the context? So here's a couple of brief examples and just focused on that idea of an unfair, deceptive act or practice that the FTC is that's how the FTC is regulating these activities and bringing enforcement action. So you see here there was an order um, basically banning a well-known healthcare company from sharing sensitive health data for advertising. And the reason I point that out is because advertising isn't what we're talking about here, but the concept of using or misusing sensitive health information is something the FTC has been focused on addressing, and I'm certain will continue to address due to the significant consumer impact of that activity. So you'll see here that this company had repeatedly promised to keep health information private and use it for certain purposes. And here it says for non-advertising purposes, but you can see how this would extend into things like artificial intelligence usage. And there's this concept of appropriate use and then usage that goes beyond that, and potentially could be a misuse of that data. Another similar kind of case where the FTC brought a complaint against a company called Monument that supported um, that had a substance use disorder, and that was the focus of Monument services. And at the same time, there were some privacy promises that were not being upheld, and the FTC took issue with that and brought some action against this company. Again, the focus being on sharing of sensitive health data or use of that data in a way that was not consented to by patients. So that again is a focus that the FTC has had over the past several years. And you'll see here that um, some of the things that were required based on these actions are identifying what user data was shared or you in this case shared, but sometimes could be misused, and then having that data deleted. There's even been cases where the FTC has required companies to delete the algorithm that they've used or created based on data, the data used are collected in an improper way. So sometimes even the product itself that's been developed using personal data becomes part of the enforcement so that the product is based on kind of like you could think of the fruit of the poison tree that we hear about in law school. It's that same concept, but with data. That algorithm might itself be not containing personal data, but it was created in a way that was inappropriate. So that algorithm has to be destroyed. And one thing that to keep in mind too, sometimes when it comes to privacy, we think of de-identification as this simple process where, for example, hashing is this idea of replacing certain values in data with a hash. So it scrambles certain parts of the data. Um, the FTC has been really clear that certain kinds of anonymization techniques that we're used to using, especially in the ad tech space for advertising technology, um, aren't necessarily anonymous. And so being aware of exactly what kinds of data is used in terms of AI training and other models, um, that is really key to understand what is actually regulated and what kind of data you're handling. So I'll close there. I think I'm right at time, so I'll pass it on to the next speaker.
All right, thank you so much, Paul. So next we have two speakers, Kelly Henderson and Dr. Britta Hansen, discussing scope of practice considerations for AI. Kelly and Dr. Hansen are both joining